No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. It's our monthly law clinic this evening where we're going to try and answer a range of questions that don't normally fit into our other ones like labour law, property law, all those sorts of things. So these are all those other questions. I'm joined once again this evening by attorney Arinda Trutter, and she's an attorney at Skuman Law Inc. Attorneys, Conveyancers and Notaries Public, and they practice here in Cape Town. Arinda, good evening. Welcome back to the show.
Thank you so much. Happy to be here.
We've got just a few emails we need to get through, but if you have any questions, you can call us on 0892 10 20 10, or you can SMS on 40938. And once you can leave your name and number with my producer if you call in now, and we'll get back to you as soon as we're done with the emails. Right, Arinda, we've got a few you have to get through, so let's start with this one first. It says, my husband and I are needing to have a will done, but I need some advice on what questions I need to ask once we get to the attorney's office. Basically, it's a second marriage for both of us, and we each have 2 children from our previous marriages. We are married anti-nuptial contract with accrual, and prior to our marriage, we bought a house together. My husband put in 70% and I put in 30%. I need some advice on how to set up this will. All our children are young teenagers, but we need to make provision for all of them in the will. How do we go about allocating the house, for example? If my husband were to pass away, how would it work with me only having 30% ownership, and then there's his children who I assume would inherit his? I imagine I would have his 70% share, or his children would have his 70% share, and vice versa with my children having my 30% if something were to happen to me. Also, I do have some policies which I had before my marriage which nominate my children as the beneficiaries. Am I correct in thinking that this wouldn't form part of my estate but would be paid out directly to them?
Okay, so to answer the last question first, all policies don't form part of the estate. She's correct in saying that. So that would be paid out directly to the person that you've nominated on the beneficiary form at the organization. So important thing there is to keep that nomination up to date. If something changes, you need to update that, because that's where that's going to pay out. So you don't even need to mention it in your will. They are already protecting their assets by being married out of community of property. And what that means is that both their estates are completely separate, and each one would be able to do with his or her estate as they please. Which means, should she then leave her 30% in her will and he leaves his 70% in his will, it would go to the children if that's how it's stipulated. The thing is, what I was just wondering is if they registered the property 70-30 at the deeds office.
I think so. I'm not 100% sure, but I think so.
Sometimes it happens where they put in capital 70-30, but at the deeds office it's still registered 50-50. So maybe that's just something she needs to make sure before they go to attorney to clarify that. Because you obviously can't leave a 70% share if you are only owner of a 50% share. So if they stipulate it that way in the will and one of them should pass, then the accrual calculation will be done first, as they are married with the accrual system, which then means that either the surviving spouse will pay money into the estate if the surviving spouse accrued more during the marriage, or the estate needs to first pay out to the surviving spouse, depending on who accrued more. Only after that will the rest of the assets be bequeathed as in the will. So if she leaves her 30% to her 2 children, that will mean effectively they each get 15% of the property, which is fine. But now, if you look in the long term, this is going to mean at the end of the day there's going to be a property with 4 children and each owning one a 6th year and a 4th year and a quarter year. And it's going to be hard to determine who's going to stay in the house, who's going to get the rental income if they rent it out, who's going to pay the rates, who's going to pay the taxes. It's always hard to have multiple owners of a property. But if one of them pass, obviously the beneficiaries then have the opportunity to enter into what we call a redistribution agreement. So one of them can then say, I want the 30% share in the property and I'll pay you out the value of it. Or she can even say in a will, want my 50% share to be sold and the proceeds divided between my children. It's going to all depend on how they structure it going forward, what they actually envision for the property going forward.
And also depending on how it's been registered at the deeds office.
And depending on how it's been registered, because you can't leave more than you actually own. So I would say go to the attorney's office with those questions in mind. What is your property registered as? And what do you envision for the property going forward? Who needs to own it? Who needs to live there? Because if you want one of the kids to live there and the others just being paid out, fine, then stipulate it like that. Or you can even build into your will that one of the kids have lifelong rights to stay there until they pass. So it will all depend on how
it's
you
almost
want
like a
it.
usufruct for one child.
Yes, it will be a usufruct.
So it's quite complicated having
It's
four
quite-
children and different percentages, and it's
It's gonna be
can I
messy going
suggest that
forward.
they go and speak to a lawyer that deals with wills? This is what
Yes,
they do
definitely.
all the time, not any other form of lawyer, or possibly not even the bank. You need
No,
to go
no,
and speak to a
definitely
lawyer
not a
especially with a
bank.
complicated will like this.
Yes, because this is a complicated will, and I would also suggest speak with someone who not only does wills, but who also attends to the administration of estates, because they will understand if the will is structured like this. This is what's going to happen when you pass away, and they would be able to tell you almost the future. This is how it's going to be distributed, and that will give you an idea of how to structure it now. So it's a very specialized field when it comes to a will this complicated.
Okay, right. So I knew there was a really good idea having just one child. Definitely worked out. It's a lot easier that way. Right, okay. The next email, it's from the listener. It says, I've been separated with my partner since 2016. We were staying together with the children until we separated in 2016. When we separated, we made an arrangement that the eldest child, he was 4, will stay with my parents, and the younger one, she was 2 back then in 2016, will stay with the mother's parents, as both of us are based in Joburg because of work. It has been like that until now, so it's been, a year and a bit, I would imagine. We had an arrangement for visitation so that during school holidays, the other one must visit one family and another school holidays, the other one will do so. The problem started when it was my daughter's turn to visit my family. I was told that I can't have access to my daughter until I get back together with the mother, and I was told that I have to pay damages in order to have access to my daughter. When they wanted the son to visit them, they just phoned and informed me and go and take him without any fuss. We ended up having a family meeting to resolve the denial of access to my daughter, although it was resolved. But every time when there was some disagreement, they resorted to blocking access to my daughter. Now, in December this past year, in 2017, the mother of the children said she wanted to take the child who is staying with my family so that he can stay with her family. She started by going to the social workers, then the social workers referred the matter to the children's court. When we arrived at the children's court, they told us they can't decide the custody of one child, it has to be the custody of both children. We filed our affidavits, and they said that they're going to conduct family visits, and then they'll call us later. Now I want to know what might be the final decision of the court on this matter. And then today I got an email, from the same listener to say that since they sent that particular email, the family advocate has already called, and he advised that the children are still young and they need to spend more time together, and he advised that every weekend they must spend time together, alternatively between the families. Even with the advice from the family advocate, they are still denying my daughter to visit my family. I went back to the family court only to find that the social worker who told me she can't help me, as the advocate who is handling the case is on leave and will be back on the 16th of March. It just sounds like a slight nightmare, and the fact they can't really ignore the instructions from the family advocate, surely.
Firstly, there's no rule in law that says you need to be with the mother or stay with the mother to have access or visitation to your child. As the biological father, you automatically have those rights.
This is her parents saying you have to get back with our daughter before we can.
It's crazy. There's no such thing, and I'm unsure which damages they are referring to. I'm assuming it's maintenance. But
I don't know.
In that case, both parents have the obligation to pay maintenance to maintain the child based on what their income is and their means and the needs of the child.
It's funny that it's just the daughter that
yes, because he's not giving them problems, so I don't understand why they're giving him problems. But he is on the right route with the children's court, because what the court will now do is appoint the family advocate, which they've done, to look into the situation, do family visits with both families and assess the needs of the child and the best interests of the child, and then make a ruling. So I understand here that the court is saying they can't look at the separate children's custody because they are so young still. But there is case law where the children have been placed with different parents, even if they are this young. It will all depend on what their best interest is, who can look after them properly, and who can provide for them. So it's impossible for me to tell him what the court's outcome might be. The court can order that the child stay with the mother's parents or with the mother, and he has visitation rights and pays maintenance, or vice versa. the court can also order that the children need to stay 1 week with the one family, 1 week with the other family, depending on...
Well, that seems to be what they have said,
Yes.
alternate weekends with different families.
So they can do that. But what I would propose is when you go to the children's court, rather sit together as a family, discuss what would be best, how do we want the custody to be, how do we want the visitation to be. Put it all together in a parenting plan. The family advocate can assist you with that. And make that parenting plan a court order. Because then, if she then refuses him to see the child or doesn't let him take the child, then it's a contempt of a court order. And
I can't quite make out whether, because he just says the family advocate called us.
yes, so
And has advised that the kids are too young, they need to be together on the weekends. You can't have one here and one there. And even with the advice from the family advocate, they are still denying my daughter to visit my family. So
Yes.
they seem to be ignoring the family advocate
they're completely
anyway.
ignoring it, but at the end of the day, the family advocate's ruling is not final. The court still has the final ruling, and the magistrate will need to decide either this way or this way. So the family advocate only makes a recommendation to court. So I would say push through, get that order from court. If you can, get it into a parenting plan without too much fuss so that it's in writing, instead of going the whole fighting route. Rather decide on it beforehand and make the plan a order of court. Then you know, this week I have the child, this holiday you have the child, and we take it from there.
Right, we've got a very long one in coming up, but we'll just take a break and take a shorter one before we get to that one. It says, my baby's mother's refusing to let me see my child. I'm staying with my wife and she's bitter about that. And the baby is only 7 years old. I have been paying maintenance since day one and she wants a lot of money, more than what the maintenance court ordered. Every time I must come and fetch the child, she changes at the last minute and then says I can't see the child. So he's obviously married, living with his wife, and then he's had a baby with another lady.
another
The child
lady,
is now 7 years old, and the mother of the child is obviously demanding more maintenance than he could possibly afford, or that the court ordered, and then doesn't let him see the child at the last
She's
minute.
also refusing that he sees the child, which is completely unacceptable. Same story as the previous one. You have the full right as the biological father to see your child, to visit your child. And this is not based on the maintenance you pay. Just because you pay maintenance, you don't need to see the child, or vice versa. The two are completely separate from each other. Maintenance is an obligation and visitation is a right that you have as a parent. So the fact that he has been paying maintenance is good for him should the matter go to court, but that doesn't, even if he didn't pay maintenance, still wouldn't give her the right to refuse him access to the child. So I would propose the same thing here. He needs to go to the children's court and get an order saying that he has visitation rights this time, and this time. So that if she refuses, then he can actually call the police and bring the police out and they can get the child. Obviously, you don't want to go that route, but if you do it once, she's not going to refuse you again. And the maintenance side of it, he needs to go to maintenance court, take proof of his income, his expenses, show them this is what he can afford, and then the maintenance court will assess the reasonable needs of the child. And this doesn't include the needs of the mother, only the needs of the actual child. And based on the needs of the child and his income, they will make an order to something that he can afford. The maintenance court will never make an order on something that is unaffordable to you.
So it almost sounds to me a little bit like possibly she's using the money as leverage to, you pay me more money, then you can see the
Then
child.
you can see
almost.
the child, which is
You can't
completely
do that
unacceptable.
either.
No,
No.
completely unacceptable.
No, that's not right. So he also needs to go to the children's court, possibly speak to the family advocate.
Yes, or a social worker.
social worker, and just
to get the case there, and then definitely go to maintenance court and get a deduction on the maintenance if you can't afford it.
Okay, I think he's okay with what he's currently
With his
paying. It's just that
yes.
she wants more and more and more all
But
the
then
time.
she needs to prove why she needs more, and if it's not reasonable, they will throw it out. If it's dog food and things like that.
Holidays to wherever.
Yes,
Yeah.
I've seen interesting things like that. Yes.
Right, it's our monthly law clinic, and my guest this evening is Arinda Trutter, and we'll be back with you in just a moment.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, okay, we've got a couple of questions coming in on the SMS line. It's 40938. We've still got a few more emails to get through. Very quick one off the SMS line. It says, how long does it take for Home Affairs to change your marital status after a divorce order?
That's actually a very interesting question, because in previous years, the court would actually send your divorce order to Home Affairs after the divorce, but they don't do that anymore. So the onus is now on you. Once you get divorced and you get your divorce order, to take it to Home Affairs for them to change it. Otherwise, they're not going to change it.
Okay, so if you've been waiting and waiting, no one's doing
Then
it,
that's
you've got
the
to go and
problem.
take it.
You
That's
need to
obviously the
take
problem,
it.
yeah.
Yes.
Okay, I didn't know that, actually. Not that I'm likely to be getting divorced anytime soon, but yeah, just thought I'd mention that. Okay, quite interesting. Right, there, another short one says, the wheels of the car was using was stolen inside the parking area of the company I work for. There is a security company hired or employed by the company that I work for. My question is, who must take the blame or account between the company I work for or the security company? And who must be responsible for the replacement of the damages between the two companies and me? The vehicle is not insured.
Yes.
That's quite interesting, actually.
Very interesting facts, and it actually came up in a Supreme Court of Appeal case not so long ago.
Same sort of thing.
Same sort
Okay.
of facts, except the person's whole truck was stolen, not just the wheels of the car. And the court in that case held that the person whose stuff was stolen did not have a contract with the security company. So the security company didn't have a duty towards you, so you have no claim against the security company, even if they are negligent. So his only claim here would be with the actual company, the employer. But it's going to depend on your agreement with the employer. Did they say you can park the car there and it will be safe, we can ensure that? Or did they say you park it here at your own risk? Because then they also don't have a duty. So if he can prove that the employer had the duty to look after his car while it was there, he can claim from the company, and the company can then again claim from the security company. But he has no direct claim from the security company.
Sadly, a lot of these parking places, they always have these big signs
There's
up,
always
park here
that
at your own
sign.
risk. And if that's anywhere on the property,
Then
you've got
there's
no
nothing.
case, sadly.
There's nothing, yes.
Right, okay, I've been trying to avoid getting to this next one because it's quite distressing. It says, I have a 13-year-old niece that was raped while staying with my cousin in 2014 after the passing of my mother, who was taking care of this child at the time. After the child was raped, she was taken by the social workers and admitted to hospital for forensic examination and for a treatment to find out whether she had contracted HIV. I was contacted by my cousin telling me that the child had been taken by social workers and I must immediately go to their area, but I went the following day. When I got there, I went to the social worker's office and got hold of the social worker handling the case. She told me they've taken the child to a place of safety and we should arrange a day to go and see the child. And we decided on a date. I can't remember the exact date, she says, but it was 2014. We went to the area where the child was, but we met at the social worker's office, and the social worker then took me to the place where the child was. She was not handling the case anymore. It was handed on to another social worker. The child was no longer in the place of safety anymore. She was with a foster parent. I met with the foster parent and the new social worker and exchanged contacts, and I got to spend a little time with the child, and later we parted ways. I contacted the new social worker after a few months, asking if I could apply for the child to have a home in Cape Town because it was closer for me to be able to visit the child. He agreed, and that was in 2014. I followed up with him the following year. He told me that the waiting list of homes is very long, and they're waiting for a response, and I left it like that. In December 2017, the child was raped again, now by the husband of the foster parent. And now the thing is, the child was examined and tested for HIV and was found to be HIV positive. And when I looked at the situation, I found it impossible that the child has attracted HIV on the second incident of rape. When I asked the social worker about the child's health status before she was transferred to their care and the foster care, there is no record of that information, but the child was in the care of social workers. When I asked why they don't have this type of information, I was told that it's private and confidential and they can't have that information. Now I'm given a form by the social workers to take her to a doctor when I'm taking the child to the doctor. I'm getting confused because it shows now they were playing mind games with me when they said that they can't have that information about the health status of the child. I suspect that the child might have attracted HIV from the first rape incident and nobody knew because no one cared, because if somebody did care, we would have known, and the child was never taken for a checkup after she was transferred to the foster parent. Because a rape victim is given medication to prevent HIV, but this child never got that treatment. Legally, what action can I take against these officials who are playing mind games with me instead of admitting that they have failed the child? That just so distressed me, that email. The child is really, it's just still distressing me.
It's an extremely sad story, and it's not something that you want to hear or that you want to read or that you want to know is happening to a child. It's not clear from these facts where the child's parents are or who the legal guardian is. The listener is obviously trying to step up to the plate, so to speak, in this case. But I also don't understand how the child is with a foster parent, but then the social worker is letting the listener take the child to a doctor, which doesn't make sense. The whole situation seems a bit not above board. But what I would suggest is that the listener appoints an attorney to...
And legal aid, I'm sure, would be able to help.
Yes, legal aid would definitely be able to help. Assess the facts, put a timeline together, and get as much evidence as you can. But now, to institute a claim on behalf of the child, which is what we are looking at here, you need to be the legal guardian of the child. So I would also suggest that the listener try and apply to become the legal guardian of the child, if that's possible. Because to get the medical information and the case files, all of that is confidential, so they won't just hand it over. Even if you become the legal guardian, they might still say, but this was in a time when you weren't, so you need to apply through the court system to get that evidence. But obviously, if you get that evidence and you can prove that the social worker, or workers in this case, were negligent and they didn't do their job properly, you would definitely be able to institute a damages claim against them and also report them to the Board of Social Workers, because this seems like there was a lot of negligence happening here.
I think your first move is to go off to legal aid.
Definitely.
They would be able to help you.
Yes, with all the different steps and which route would be best suited.
Right. If you'd like to call in and speak to Arinda with any question, not property or labour law, you can call us on 0892 10 2010. 0892 10 2010. Right. The next email, Arinda, came with loads of attachments, which I sent through to you. And there's also another one, which is, I was very confused by this one. It says, basically he's talking about a marriage out of community of property, and it didn't go to court at this. He was trying to get divorced. He wanted to divorce, and I was told that my marriage was out of community of property and refused to go to court unless I agreed. This was the legal aid lawyer. The certificate clearly indicated in community. At the same time, the house in KwaZulu-Natal, which I bought before 1994, was being sold. A new title deed, which was to include my ex-wife, was to be issued before the transfer. Also find that a bit odd. Why would you issue a new title deed to include the ex-wife when you're about to get divorced and the house is all yours to start with? Anyway, despite all the papers we signed confirming we were married in community, legal aid said no. At first, both parties agreed marriage was in community. Later, things changed. All this affirmation is contained in a file which my lawyer got from legal aid. I then went to court on my own, and on the 20th of January 2017, the divorce was granted. The marriage was in community. While I was trying to find a lawyer to claim what belongs to me, my ex-wife's lawyer sent discovery, obviously the discovery documents from the case, which was later followed by a letter saying that they would be taking action if I didn't respond, and I didn't. Thereafter, I got a call from my ex-wife's lawyer offering to assist me to finalize the matter. By then, I had my own lawyer. They told him they intended applying for rescission. They didn't. Instead of going to court in December, they sent a letter saying that she paid debts with most of the pension, and I must now leave her with the house because I took all proceeds from the house in KZN. If I don't agree with the above, then they'll go to court. They have not. My lawyer has decided to continue with the claim. To our surprise now, in their letters, they're now saying the marriage is in community. Didn't he say that earlier? It was all in community at the divorce. Then it was out. Now it's back in. Given what happened to me, I feel this practice must be exposed. To me, it looks like, when he talks about legal aid operating like, I'm not quite sure what this is, but there was a lot of documentation. It's a lot of confusing documentation because some of it said in, some of it said out. And then there was something about if you were Black African and before 1994, I think it was, if you got married, according to the documents there, it says automatically you married out of community of property. But then they would have had to sign an ANC contract, surely.
So I did some research on this because I also wasn't sure, and it seems that their marriage was governed by Section 22 of the Black Administration Act, which says that if you get married, in terms of that section of that act, you will automatically be married out of community of property, unless the parties both decide, jointly agree, that they want to be married in community, and they declare that on the day to the marriage officer, which I think is what happened here. So I don't understand how his attorney told him that the act says if you didn't want to be out of community, you needed to enter into an antenuptial contract. Because that's silly. An antenuptial contract is for being out of community of property. So all they did was declare to the marriage officer, we want to be married in community of property. And that's why their marriage certificate also says in community of property. So if the attorney did proper research here, then this would have been clear from the start. So either way...
It wouldn't have confused me.
Yes.
I'm confused by this.
So either way, the divorce is now granted now, and it was declared in community of property, and the divorce order says that the joint assets need to be divided equally between the parties. So he definitely has a claim now against his ex-wife for 50% of the joint assets, which includes 50% of the pension fund. But what he now needs
And the house.
And the house. But what he got the full proceeds from the house.
And she paid all the debts.
And she got her full pension. So now he needs to know if he is going to claim 50% pension, she can claim 50% of the proceeds of the house. So it's going
And
to...
would he not have to pay 50% of all the debt she paid?
Yes, because everything is in community. So it's going to be tricky to figure out who owes what now. But I don't understand why her lawyers are now sending discovery. Makes no sense because the divorce is granted already. So the case is basically done unless they've issued summons
Something
for
else.
the claim
Yeah.
already.
But basically you're saying it was in community.
It was definitely, as far as I can see, it was in community, and it should have been said to him from the start that it's in community, and it would have cut out a lot of this admin and back and forth, and he would
and
have
possibly
been,
more expenses that they're having to pay lawyers' fees
and
and all
it
that
would
sort
have
of
been
thing.
clear, and the pension fund wouldn't have paid out to her, and the property wouldn't have been transferred. All of that would have been cut out if he was just advised properly. So if he wants to report anyone, you can report an attorney to the relevant law society of the province. And if you really think you have a damages claim against an attorney for wrongdoing or negligence, you can always issue a civil claim. But
And you
he's
can get the information from the law society will be able to help you,
yes,
to
and
point
his,
you in the right
his attorney
direction.
would also be able to assist him with that.
Okay, right. Next one. Hope you're not going to get confused by this one now. I did not contest the summons of the divorce, and my wife forwarded a decree of which I didn't contest that for 21 days, as she had told me that she'd stopped the divorce. She's working for the government. We were married in community of property, and we didn't split. And on the decree, she stated that whatever is in one's possession, that person will keep it, and we moved the BMW to her friend. The legal aid cannot assist as I didn't contest it, and it's not going to be a winnable case, and I'm entitled to 50% of everything, including her pension. I'm stuck and unemployed. Please help.
So this is a situation where someone took a chance and got a divorce order granted without the other party's knowledge.
I actually know that happened to somebody I actually know. I don't know them personally, but I've heard about this before.
Yes.
It's not the first time I've heard
Because
this.
she obviously told him, no, I'm not going ahead with the divorce. And in the back end, she was going ahead and changed the in-community to each party just keeps what he or she has, which obviously is working out in her favor. But it's unfortunately he didn't contest it. So in the court's eyes, he didn't contest the divorce and the decree is now granted. So what he now needs to do is apply to the same court who granted the divorce order for a rescission, and he needs to prove that he was placed under the direct impression that the divorce is not going ahead, and that's why he didn't contest it. And perhaps he can get away with that. The courts don't like to entertain this type of application, but that would be his only route forward.
Right, so if you get something telling you that you are, there's a summons of anything, seriously, go and find out about it. Don't just say,
Yes.
oh, because someone told you, don't worry about it. You need to worry about everything.
Especially the person trying to divorce you.
Yeah, you don't ignore that.
Yes.
Okay. Right. The last SMS says, can you please assist with legal advice regarding our family home? My mother passed away 4 years ago, and we discovered the title deed of her house is in my brother and his wife's names. It's only the two of us now. His wife has divorced him, and she now wants 50% of my mother's house. Well, please help.
This confused me because I wasn't sure if the property was placed in his brother's name before the mother passed or after the mother passed.
I don't know, she just said they discovered the title deed
Yes.
after she'd passed 4 years ago. They
So-
discovered the title deed, and it happened to be in the name of this person's brother and his wife.
Yeah, so if it was transferred before the mother passed, then obviously it needed to either be sold to the brother or donated to him, and there would have been a proper paper record in the deeds office of how the property got into the brother's name. If it was left to him in terms of the mother's will, then that would have been an estate transfer that would have been endorsed on the actual transfer. But the question, it seems here, is about the ex-wife trying to get 50% share of it. If it was transferred before the mother passed away, and the brother and the wife was married in community of property, then she would have full right to get 50% of that property. If he got it through the will and it was left to him and the will specifically excluded it from any inheritance, then she would have no claim against it.
So even if it was in her name?
Even if it wasn't, because it's only in her name because they're married in community of property.
Okay.
So that's where I get confused with if it was before or after.
Okay, well, if this listener, Ida, her name is, if you can call us maybe on 0892
Yes,
10
I think
20
that is
10.
just to clarify.
Just to clarify that, and maybe then we can help you further because we'll have more information.
Yes.
But, sorry, at the moment we're not quite sure when this was transferred and how
that
your
would
brother was
depend
married
if the wife has
all that sort of thing.
a
Yeah.
claim, yes.
Okay, so if you could please call us 0892 10 20 10 and we'll hopefully be able to help you further with that. Right, we've got some calls holding, but before that, just ask you this. I'm going through a divorce. I'm married, anti-nuptial contract. Does a trust form part of the accrual where both partners and an external party are trustees? The trust has fixed property.
So a trust won't form part of anyone's separate estate because a trust is a completely separate entity with a legal personality. If you receive income from the trust as a beneficiary, that would form part of your accrual unless it was stipulated in your anti-nuptial contract that that is specifically excluded, or if the trust deed itself says that any income derived from the trust will not form part of any marital, joint or separate estate. So it just depends on what the actual trust deed says and what your anti-nuptial contract says, but it shouldn't form part.
Right, let's go to the lines now. We've got to take a quick call. Edith in Neisner. Excuse my voice has gone all funny tonight. Edith, excuse me. Edith in Neisner, good evening.
Good evening, Colin. Yes. I'm glad to go on this platform this evening. I want to know that after you've laid a one-on-one complaint and you've never been helped and you've placed the children under supervision, guardianship of the state, and then they disclose. What is the right of the guardian to do when there's disclosure?
Edith, we're a little bit confused.
What is the right that the guardian of the child, if a child is placed under guardianship and the child is close to the social worker or the psychologist incidents, and those incidents need to get corrective therapy or justice.
So, and then but the social worker isn't then passing that information on to anybody else. Is that what you're saying?
That's right.
Okay, so the child is disclosing an abuse, for example, to the social worker, and
Yes.
it's not going any further than the social worker. Is that what you're saying? They should be. Is that what you're saying? Okay, so what happens then? I mean, what can you as the guardian do? How did you find this out, though, Edith, that there was a problem?
In the first place, I'm now in the Western Cape. I was staying in the Eastern Cape, and these things happened there. So I'm not going to discuss everything.
No, sure, yeah.
Yeah. So, and then I was arrested because I reported this disclosure. I went to court 3 times.
Were you the social worker, Edith?
No, I am the guardian.
You're the guardian. Okay, so you knew about the problem, and you knew that the social worker hadn't done anything with it.
That's right. I reported this to the police, and I was arrested.
For what?
First, they stated that I tell the child I make up the story and tell the child to repeat it.
Oh.
And then we went into a hell of a turmoil of victimization that we had to leave the place, and for 1 year nobody helped us. I then forcefully asked them to keep the children in a place in safety. I then myself had a TIA attack, and I asked for help. Nobody assisted us. And then the disclosure came out afterwards.
It sounds like a nightmare.
Nothing. Yes.
How's the child doing, Edith?
The child now, after I asked them to give corrective therapy and I forcefully placed them under guardianship of the state, they now are, there's signs of change.
And they're doing better now.
No justice.
Well, what does Edith do? I mean, it sounds like she's in a rather terrible situation here.
Yeah, it sounds like a horrible situation, and I'm not sure because it seems like she's already tried you've already tried all the routes that you can take.
I've done everything. I've
You've
done
gone to the
everything.
court, you've gone to the police. So my only advice is to get an attorney and to take the matter back to court, because that's your only route to get justice.
Mm-hmm.
Because
Oh,
I don't think the police are going to be able to assist you with this. It would need to go through children's court.
I've laid a 101 complaint already. They are now busy working on it, but there's so much of damage that has taken place along.
No, I can completely understand.
But the only thing now that's withholding justice is the information from social welfare.
Well, you can go directly to the social welfare board.
I've done that.
Yeah, so you've
Oh,
really
you've
tried
done everything.
everything.
And the social worker that worked on the case never left any history in the files, or they didn't hand over reports, and they said they cannot do anything. But the information is at the house where the children is.
Oh gosh, Edith, it sounds like you've done an awful lot. I mean, I think you've done a lot more than a lot of other people would have done. So you've done a great thing for these children. But I hope that you're going to get this sorted out. I mean, there's nothing much that you can help with here, Orinda, I don't think. And everything
my
that you're
advice you've
suggesting,
done
she's already
already.
done it, So, Edith, I think you must just be strong. You sound to me like a very strong person. And I think if you just carry on and you say the attorneys are helping you at this stage, and as Orinda says, that's possibly your last chance.
That's-
You're
and the
going to
best route to follow
the best
at this
route to
point.
follow at this stage. You've tried everything else. Well done to you for doing all of that. But I don't think we can help you.
I've tried attorneys, I've tried everybody. But I seem to be now in the right place. The only
Good
thing
luck.
that's withholding this is the social workers is withholding justice from us.
Yeah, well, I'm sure the attorney will look into that as part of the case, I would imagine. So
Yes.
good luck with that, Edith, and I wish you much strength. Thank you for all that you've done so far.
Good luck.
Thank you for
Thanks for the call. Good night to you. Bye-bye. We'll be back with you in a moment.
No one lays down the law like Karen Key. This is the Law Report on SAFM.
Right, back to the lines. Heather in Port Elizabeth, good evening.
Hi, thank you for taking my call.
Pleasure.
I have a situation. I am a foreigner here in South Africa, and in 2013 I recommended a woman for the Bateau Pelly Awards, and she came in second place, a 20-year nursing sister in a public hospital. She won the award, and part of the award on national television was to receive an Oxford University scholarship. Since 2013, we've been trying to get that scholarship and have had the runaround. We're looking into it. We'll get back to you. And last year, they told me that either the scholarship never existed or it disappeared. And so we put forth a proposal to go to NMMU here in PE. And I'm still having a problem that no one will take responsibility. It was on national TV. It was in the newspaper that this is what she won. And I'm wondering at this point what I can do legally. Can we require the Bateau Pelé to come through and financially give her at least some kind of a scholarship?
Yes, you would definitely be able to compel them, because if you look at it from a legal point of view, there's a valid contract between her and this organization. There was an offer and there was acceptance. So it's a completely valid contract and they need to uphold their end thereof. So if they're not doing it, it's a breach of that contract. Even though it was a verbal contract in this sense, they still had the obligation. So if they're breaching it, then you can claim damages on that, or you can get an order for specific performance that will force them to give her this opportunity.
Now, coming from a foreign country here, would I just employ a lawyer to pursue it, or do I have to go through a certain kind of a lawyer in this country?
It will depend on what your connection with the matter is. Otherwise, I would suggest that she directly interacts with the lawyer, because it's technically the contract between her and the organization. But you would be able to just go to an attorney here and explain the facts, and they would be able to take it forward.
There wouldn't have to be a specialized attorney of any description.
This is a normal civil claim, so you would be able to go to a normal attorney.
And do you think in this case, obviously she's a public servant. She's not paid a whole lot of money. That's why this was such a big deal and exciting for our whole city. At this point, would she be able to go to a lawyer, for example, and say, look, I think I can sue for damages, and then the lawyer can get the money out of whatever she gets rather than having to come up with money herself?
There are lawyers that do that type of work. We call it contingency fees, where they get paid only when you win the case at the end of the day. Not all lawyers actually work on that basis. But if she falls in the bracket, then she can always apply to legal aid, and they can assist her pro bono.
And there's also an organization called probono.org, and they basically, that's what they do,
Yes.
depending on the case. They will look at the case and see whether it is something that they would be able to handle, because they have a panel of attorneys all dealing with different issues, and possibly get hold of them, Heather. If you look them up on the internet, probono.org. I think it's either just .org or .org.za, but just I think it's .org.za. probono.org.za. Have a look there, and just have a look, because that's what they do. They do pro bono work. It's all free. So
This
depends on the
would be-
case.
This would be kind of a high-profile case, so I think you would get someone to help you pro bono.
Yeah, and at this point, for me, it's just the principle of the matter.
Absolutely.
No, completely.
Absolutely.
Okay. Well, thank you very much. I appreciate the
No
help.
problem.
Gosh, Heather, good luck. I really wish you all the luck, because that is something that really aggravates me if that
Yes.
happens. So hats off to you for following up on this. And it's been how many years now?
5 years.
5 years. Oh, no, that's
To the
ridiculous.
point that we've gone through 3 minister changeovers and directors, and it's always just somebody passing the buck.
No, well, you get hold of
Shocking.
probono.org.za. Go and have a look. I'm sure this is a case that they would very much. I can't speak on their behalf, but go and have a look to see if they would, and get in touch with them and see if they'd be able to help you.
Thank you so much. Appreciate the help.
Good luck, Heather. Thanks.
Have a lovely evening.
You too.
You too.
Bye-bye.
Bye-bye.
That would seriously anger me.
Imagine winning
In 5
something
years,
like
something
that,
like that, and then
being in the paper
Oxford
and then you
University-
don't get the actual
Oh, no.
award. No, it's crazy.
right. Okay. Bongankosi in Durban. Good evening.
Good evening, ma'am. How are you?
Very well, and you?
I'm okay, ma'am.
How can we help you?
Good evening to your guest as well.
Good evening.
Yes, I want to ask one question here. My father got married to my stepmother, and they got married out of commit of property. And then my father passed on. When he passed on, then the stepmother chased us away. But then when the time came for my father's estate to be wound up, the mother and the stepmother came with another certificate now, which showed that they were married in commit of property. But now the date in the certificate shows that that the second marriage happened after the father has passed on. But then she used that certificate to wind up the estate, my father's estate. And on top of it, she underestimated the what's called the estate. Maybe for it not to go to the executor. So then in that case, we as the children that were not in the marriage, what benefit could we get from the father's estate? And then if it happened long time, like my father passed on in 1987, I think more than 30 years now.
So when did she do this? The changing.
In the 90s, my father passed
It's long, yeah.
87, then she just went to wind up the estate in the 90s.
Was there a will, Bongankosi?
It doesn't look like there was a will. That's why she was able to go to the executor yeah.
Is it a bit late now, Rinda?
It's a bit late now, because obviously she then was appointed the executor, because it was not in a will. So she just handled the whole situation by herself and bamboozled her way through it. But it's a bit late now. Even if you go to the master's office now to try and fight that, I doubt they'll even have the records anymore.
Yeah, because we found some records from the master. That's where we got to know that she underestimated what's called the estate. Because my father was a businessman, but she only showed only few property from my father's property, and then she denied that my father had kids.
No, I completely understand. So
How old were you at the time when your dad passed, Bongankosi?
When my dad passed, I was 22.
Okay.
But the other siblings that were young, one was about 2 years old.
Sure.
That's fraud, basically, what she
It's
did.
fraud, but to
But you
fight
can't
it
now.
now, it's too late now.
It's too late.
The claim is prescribed completely, and you won't even get those records back. So I won't suggest.
Okay, let me ask a question. If it wasn't late, how would you suggest which route to take? If let's say it wasn't late.
Yes, then you would have to first go to the master of the court, the one that handled the winding up of the estate, and lodge a complaint there or a review. And if that doesn't work, they don't decide it there, then you can go and bring a court application to claim that the winding up was fraudulent and to have a look at it again.
Oh, okay. No, I understand.
Okay. I'm sorry about that, Bonga Nkosi. Oh, sorry, another question quickly.
The second short one. I've got a friend here. I want to know whether a marriage could be declared null and void. She got married to a guy who had raped her. She allegedly raped her. Now, because she was from a rural area and afraid of her parents, all she did when she got pregnant after the rape, the guy decided that she was going to go and pay lobola for her. Now, she didn't want to expose to her parents that she got pregnant after the rape. So this guy eventually got married to this girl. But the girl is never happy even now. She only reveals now that actually she doesn't regard the marriage as a true marriage because she only got married just to hide the fact that she got pregnant before she got married. If ever, does he have any leverage to go and perhaps ask for that marriage to be declared null and void?
If it was a valid marriage in terms of the Act, in terms of legislation, then that won't be able to be declared null and void, but she can always go to court and apply for a divorce.
Oh, okay.
Yes.
But now what happens is the marriage was in common of property. The guy then, because he tried to apply for a divorce, but what happened, the husband then just resigned from work. In fact, she took an early retirement, and then he took all his pension. Now, when she talks of a divorce, the guy says he is entitled to 50% of her estate. But then he took all of his, and then he used his. And the lady did not have 50% from his estate, but he wants 50% from her estate now.
Look, there is ways around that. A proper divorce lawyer would be able to assist her to claim what needs to be claimed and to also say that he can't claim from her. There is a way to do that if the facts are in that line. So I would say see a proper divorce lawyer, someone who specializes in this type of law, and they would be able to assist her to get what she rightfully deserves. And on top of that, get her maintenance that he needs to pay her.
For the child?
Okay.
For her,
for
the spouse. Get her spousal maintenance so that he needs to look after her after the divorce.
If she's not working, but he's not working now.
Well, maybe you should go and find a job.
Yes.
He took early retirement. I'm sure he's still capable of working or not.
So all these facts will count against him.
Oh, okay, thank you.
No problem.
Oh, okay, I've just got an SMS here from somebody, and I was going to say this because I'm one of those people that does a lot of family history research. Somebody just SMS to say that, Bonga Nkosi, you should check the archives for the documents. You can find papers there, many. And truly, thank you. Yes, that's something I was going to say that because that is how I found a lot of the old ancestor people in the family is through the wills that you find at the archives. So maybe go and look at the archives.
In fact, I do have the documents. I got the documents.
Oh, you've got all the papers?
Yeah, I got all the documents. That's why I saw that he came up with a new...
Oh, I see. Okay. All right. Yeah. Or maybe just if you say it's too late, but I'm suppose there's no harm in going to the master's office.
In going to the master's office and
just
seeing what you can do.
Oh, okay. Thank you.
Okay, well, good luck, Bonga Nkosi.
Okay, thank you.
Thanks a lot. Bye-bye. We've got about 5 minutes of the show left. We'll be back with you shortly.
No one lays down the law like Karen Key. This is the Law Report on SAFM.
Right, let's try and get through another call. Valapi in Bloemfontein, good evening.
Good evening, ma'am. How are you?
I'm very well, thanks, and you?
Doing very well. I'm just, I'm having a problem. I bought a car from an auction last year in August. And then I didn't get the sales contract. I don't know because I'm a first buyer from the auction. And then the guy told me he would send the papers he told me that the papers of the car are at the bank. The impression was those cars was of the bank. and then the bank will send everything soon as they finish soon as they report back to the bank. It's fine then. I tried in October, the papers, no one called me. I called them, no one answered the phone, only the voicemail and things like that. I couldn't get hold of any one of them. Now I went to the traffic department to find out what can they help me. What can they assist me with? And then they just check on the system only to find that this vehicle is of another person, of which I Googled their contact number. I called the person. He told me that it seems like they agree with the person whom I bought the car from, the auction. That he gave the auctioneer a car to sell the car. He never brought the money back to him. So I must pay him 20,000 to get the certificate of the car. I really don't know now because I wasn't there and no one told me about that. How do I go about registering my car? Because I bought the car, I got the papers to prove that I bought this car. And that's all I got.
So basically somebody gave this auctioneer the car to sell. The auctioneer sold you the car. You paid the auctioneer, but the auctioneer never gave the money back to the guy whose car it was in the first place. Okay, right. So now he says, obviously, and now the guy, the auctioneer, seems to have done a bit of a runner. He seems to have disappeared.
Exactly.
And are you sitting with, did you pay 20, how much did you pay for the car in the first place?
It's 55.
And now the owner wants you to pay another 20 to get the papers.
Another 20 on top of that.
Because he's lost out all his money because the auctioneer... Now, whose fault is that? Because, I mean, it was the seller who actually appointed the auctioneer.
Yes, but you don't have any claim against the seller because you didn't pay the seller anything for the car. So your only claim is against the auctioneer because you paid him money and you didn't get something in return. When you say you have the papers to prove that you bought the car, what do you mean by that?
Yeah, like a proof of payment that got the name of the car, my name and, everything of the car, registration number, the model of the car,
And do you have the details of the auctioneer?
Ma'am, I really don't have. To be honest with you, the only thing that I have, I happen to have that paper they advertise the auction with. I can't tell you where did I put it because I
was it in the newspaper, Philapi?
No, it was. They have a leaflet.
Oh, it was a flyer. Okay, because I say you could go look up the old newspapers if it was in a paper. Okay, we've got about a minute, Arinda, so we're going to be quite short now.
The only thing you can do is try and claim the money back from the auctioneer.
But he doesn't know where he is. He's disappeared.
But you need to. An attorney will be able to help you appoint a tracer to find him. We can do that. So I would think do that, try and find him and claim it straight from him because otherwise this is complete fraud, but you have no claim against the seller.
That's right.
So you need to get hold of an attorney who will find you a tracing agent.
So that you can
hopefully try
person.
and find him. Valafi, I must thank you so much, but I'm so sorry we've come to the end of the thing. But thank you for the call. Just before we go, Adam has called and his company didn't pay his PAYE to SARS. We haven't got time to call him back, but I remember from when we talked to Michael Bagram, he says that you need to go to the Labour Department and report the company.
Yes, that's how I understand it.
Okay, so Adam, you need to go to the Labour Department, report the company. They will take it from there. Okay, right. Well, my thanks once again this evening to attorney Arinda Trutter. She's an attorney at Skuman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town, and she's been my guest on tonight's edition of the Law Report program. Arinda, once again, thank you very much indeed.
Thank you so much for having me.
I'll be back with you again tomorrow evening just after 9 with Health Matters. It's our monthly phone-in tomorrow. And with March being TB Awareness Month, my guest tomorrow evening will be Dr. Justine Fargo. She's a TB doctor working for Doctors Without Borders. So join me then.